For most of the 20th century, states granted local phone services exclusive rights to their areas, effectively creating small monopolies in entities known as local exchange carriers, or LECs. By the 1990s, technological advances had made it possible for multiple providers to serve the same local area. AT&T versus Iowa Utilities Board concerns what happened when Congress decided to restructure the telephone market, ending the long-standing policy of state-sanctioned monopolies. The Telecommunications Act of 1996 required local exchange carriers to share their networks with competitors. An entering carrier could request access to an existing network through purchase or lease, or by interconnecting its own equipment. If the two carriers failed to reach an agreement, either could petition the state commission for arbitration. State commissions would be subject to rules and regulations created by the Federal Communications Commission. The Commission duly created rules governing phone service. Rule 319, the unbundling rule, listed the number of network elements that LECs had to provide at the request of new entrants. The pick and choose rule allowed new carriers to demand any network element arrangement on the same terms that an LEC had given others in agreements approved under the Telecommunications Act, without being required to accept any other provisions from those agreements. Numerous local exchange carriers and state commissions brought lawsuits attacking the act. They insisted that the authority to regulate local competition within states belonged to the states, not the Commission. The cases were consolidated before the Eighth Circuit, which held that the Commission's general rulemaking authority under the Communications Act of 1934 extended only to interstate matters. It found for the states. The United States Supreme Court granted cert.